1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်43ပြည်ရန်ဆို Alliance မောင်တောင်ညွန့် Applicant vs the Union of Burma Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Appeal before ဦးကျော်စံဦး Judge ပြည်ရန်ဆို Alliance မောင်တောင်ညွန့် Applicant vs the Union of Burma Respondent Evidence at Section 145 and 155(3) Witness unworthy of credit, falsity of statement, proof by contradictory statement, by examination of investigating officer or admission of the witness statement as exhibit. Hell, the prosecution tried to show that he was not worthy of any credit as he had made a contradictory statement to the police, but it did not prove his alleged statement to the police under Section 155(3) read with Section 145 of the Evidence Act. He had denied making such a statement. It was the duty of the prosecution to prove the falsity of his alleged statement. If he was to be contradicted, it appears that the trial court did not correctly follow the procedure laid down in Section 145 of the Evidence Act. Neither the police investigating officer was questioned nor any portion of the witness' alleged statement to him was exhibited. The public prosecutor failed to impeach his character under Section 155(3) read with Section 145 of the Evidence Act. Dokalima vs. the Union of Burma 1962 BLR 118 cc. Black Ram and others vs. State ILR 1953 2 Allahabad 197. The State vs. G1 Das ILR 1939 20 Lahore 305 refer to Mr. TP1 for the appellant, U.N. government advocate for the respondent. U. San U. Judge, the appellant was convicted under Section 302 2 of the Penal Code for causing the death of one Kolamye Alliance U.N., the husband of MAUNG, plaintiff witness 1, with a stick and sentenced to suffer 10 years rigorous imprisonment. The evidence for the prosecution is rather meager. The occurrence took place at about noon. The appellant and the deceased were neighbors and were in good terms, but the trouble started when their two small sons quarreled. According to MAUNG, plaintiff witness 1, her son, aged about 3 years, was beaten by the son of the appellant, and when her husband, the deceased, abused and asked the boy why he had beaten his son, the appellant came out of his house and asked the deceased why he had abused his child. The deceased did not deny. The appellant then went into his house and brought the exhibit stick. She said that while the deceased was sitting at the entrance of his house, the appellant struck him with the stick on the head twice and gave a third blow on the shoulder. Her evidence that the appellant struck the deceased 3 times is without any support. The Leonard trial judge made a note that the exhibit stick bore 2 marks like target mark. MAUNG, however, denied that her husband, the deceased, was armed at the time. I must ignore the evidence of Dawkins, plaintiff witness 2, as she is not a truthful witness, as it is shown in her own evidence. In Doklima versus the Union of Burma 1, I held that if a witness is proved to have made a statement to the police, though as one in distinct conflict with his evidence on oath, his testimony is negligible. The principle is that the person who makes inconsistent statement is unreliable and his evidence should be ignored. It was also held in that case that when a person makes a statement to the police and denies same in the witness box, such statement is inadmissible either in favor of or against him. The prosecution stands on the evidence of MAUNG, the widow of the deceased, alone. Her evidence is biased and very much exaggerated. According to the medical evidence, the injuries on the deceased could have been received as the result of 1 blow with a stick, though they could be received by 2 blows also, with the exception of the injury on the head fracturing the skull. The other injuries were mere abrasions. It is therefore very likely that he was given only 1 blow on the head with a stick. There is evidence also to show that when he was struck, he fell on the ground. The appellant denied that he struck the deceased with a stick. He deposed that when the deceased went into the house, he feared that he might bring a weapon, so he picked the exhibit stick, and when the deceased came out with a dart and cut him, he defended himself with the stick. He said when the deceased cut him twice, someone from behind struck the deceased with a stick. This story might be true as it is supported by MAUNG, defendant witness 5, and MAUNG, defendant witness 4. MAUNG deposed that he saw the deceased cut the appellant with a dart and the later defended himself with a stick. The prosecution tried to show that he was not worthy of any credit, as he had made a contradictory statement to the police, but it did not prove his alleged statement to the police under Section 155(3), read with Section 145 of the Evidence Act. He had denied making such a statement. It was the duty of the prosecution to prove the falsity of his alleged statement. If he was to be contradicted, it appears that the trial court did not correctly follow the procedure laid down in Section 145 of the Evidence Act. In Black Run and Others versus State 2, it was pointed out that the whole of the witness statement before the police does not become admissible in evidence, but only that part of it to which his attention has been called and that, therefore, that part alone should be accepted or admitted into evidence. It will be useful to quote the relevant portion of the judgment for guidance. Only those portions of the statement as have been used to contradict that witness will form part of the judicial record. The rest of the statement cannot be relied upon by either side in determining the guilt or innocence of the accused and cannot be used by the judge. Thus, if it is desired to contradict a witness by any statement previously made by him, the record should show clearly that the attention of the witness was drawn to that part of the previous statement which was intended to be used to contradict him, that he was given an opportunity to explain the apparent discrepancy between his present statement and that part of his previous statement to which his attention was drawn, that his explanation, if any, was duly recorded. Such part of his previous statement, if not already proved, should be subsequently by evidence which in the case of a statement recorded under section 162 of the Code of Criminal Procedure will usually be the statement of the investigating officer. See also the State versus G1-3, where it was held that when a witness is confronted with a portion of his police statement which he repudiates, the police officer recording his statement should be questioned specifically with regard to that portion of the statement, and that the practice of merely asking the police officer perfunctorily whether a particular document represents the witness statement as a whole should be condemned. In the instant case, neither the police investigating officer was questioned nor any portion of the witness' alleged statement to him was exhibited. Hence, the evidence of MAUNG, defendant witness 4, stands as it is. The learned public prosecutor failed to impeach his character under section 155(3), read with section 145 of the Evidence Act. If he had successfully done so, his evidence could not have given any support to the defense and would have become worthless. The medical officer was of the opinion that after the receipt of the injury on the head, the deceased would be incapacitated, that is to say, he would not be able to defend himself and would be helpless. If this is so, the appellant defends that he acted in the exercise of his right of private defense of the body must be true, looking at the down mark on the exhibit stick, as pointed out by the learned trial judge. If the stick bore down mark, he, appellant, must have been struck first by the deceased. It is needless to point out that in a criminal case, the burden is on the prosecution to prove the guilt of the accused beyond all reasonable doubts. In the instant case, there is only the evidence of the widow of the deceased that could be considered legally, and I have pointed out that her evidence is not acceptable at all. On the other hand, the appellant has put a reasonable defense supported by evidence which cannot be said to be false or contradictory in the respect that the conviction and sentence passed by the trial court against the appellant are set aside, and he is directed to be acquitted.